Very good morning, ladies and gentlemen. This is Jazz from Jazz Real Estate Review Group Point Cook. I just wanted to have a quick chat regarding a VCAT hearing that we had and a case that was appointed to us by the rental provider or a landlord. So just to give you a little bit more for context, this video is all about the experience they had with the rental property, the renter or the tenant you used to call, rental provider or the landlord who had this property here in Point Cook, and the issues that they had with the tenants, the property itself. It's really a sad story, but again, it has somewhat happy ending to it. It was paramount that we share this piece of video with everybody, either you're a property owner or perhaps a future landlord or you are a current landlord. Things that you could potentially learn and avoid making mistakes from. So with regards to this property here, without obviously giving the property address due to vendors or the owner's privacy, this home is in Point Cook itself. Tenant or renter has been living there from last 4 or 5 years, and they had some ongoing tenant problems in the terms of attitude and the demand or the demanding nature that renter had. But of course, the renter and the rental provider worked with each other over the years. So this home, just to be clear, was not managed by our property management team. It was managed by another real estate company. Now, fast forward many years, they had some ongoing maintenance issues with the tenant. Used to make it really big and make a big fuss out of it. So, but again, that's not the real conversation here today. The real conversation starts now in 2023. They had a ceiling collapse out of nowhere. Lucky the tenant didn't get hurt. She was in a different area. Majority of the house had a ceiling collapse in the living, dining, kitchen area, part of the hallway, for an example. So the house was unfit or unsuitable for human habitation. What then happened was the rental provider, some mistakes, of course, which I will pinpoint and I would always recommend rental providers is not to go direct and have constant communication with the renters during your tenancy because yes, I see a lot of times people would go in, visit the property to pick up a mail or pick up a parcel. They'll exchange contact details. They'll start communicating amongst themselves on the phone. Tenants start reporting maintenance over the phone to the rental provider or text messages, and they agree to something and doesn't get done. Renter has got the evidence that you agreed on something and which has not been done. This can be used against you even 5 years after the tenancy or even many years after. So it's paramount that you keep line of communication through your property management company because a capable property manager would ensure everything is documented. In case the paperwork or the file needs to be prepared for a court hearing, VCAT or magistrate's court, depending on again where you are, then at least the evidence is there. Otherwise, it's high probability if you don't have evidence that you either will be in a back foot and or perhaps you would not win the case if you don't have enough evidence to prove if your case is reasonable and proportionate as well. And this terminology played a big role in the scenario we're talking about. So a few pieces of course, education. So I'll be explaining the details about this case, but I'll also be on the way talking about the recommendations that we recommend the rental provider for do's and don'ts as well. So the rental provider contacted us because I have some relationship with them from before, sold their property in the past, and they reached out and said there's some ongoing issues with the property management company between tenants and the property management companies. He felt that they're not able to manage, and they gave the file back to the rental provider because they just had enough of the whole situation, and they felt it's not probably their cup of tea to manage that issue. November, there was a ceiling collapse, and mind you, they haven't been paid rent since then. And in some way, it worked out in the rental provider's favor as well. Ceiling collapse happened in November, and the rental provider visited the property. verbally agreed on a rent waiver, that the rental provider would not charge rent to the tenant until the ceiling is fixed. In some scenarios of this kind, the rental provider is also liable for finding an accommodation to the tenant and fixing the ceiling, or fixing or making the house habitable again. But in this instance, renter had an alternative accommodation where she was not paying rent, which also worked in this case as well in our favor. Renter did not pay the rent and was really hard on giving access to the property. Every time the property management company had to visit the property, they had to issue notice of entry. The tradies were having issues visiting the property and or performing works. The renter was also providing instructions on how the work should be done. In her understanding, the ceiling should be started from the roof itself. They don't need access to the property. It was just making it hard. And this also became a really great piece of evidence that we gathered during our meeting, which I'll explain in detail. So this video will be a little longer to explain and understand, but please keep watching the video, because this video would certainly give you a lot of insight and help you prevent a heartache and pain for potential issues that could arise in your case as well, or in your life, or in perhaps your journey. So coming back to the conversation again, long story short, the rental provider's property management company came to a point where, after issuing so many notices, back and forth emails, glad that they had emails exchanged, which came to us in a file, but a lot of information was missing. So we had to start the whole process all over again. When we took over the file, first thing we did was contact the renter and obviously empathize with them. Met with the renter in person, took a hard copy of a diary as a pen and paper, when they made notes with timestamps on the conversation. And the conversation was really strategically planned as to what we want to get out of the meeting. It was agenda based, and to ensure that we have all the information ready for the VCAT. And we knew what we were planning to do as well. And in the event that, of course, and that was made really clear to the renter. When we met the renter, there was a lot of issues that were brought in from last 2017, 2018 maintenance problems. So conversation was then fast forward, and we instructed and requested the renter to stick to the facts of 2023 and 2022 November. Back and forth, the renter had her own issues and concerns. Virtually, she just simply said she's not vacating until her conditions are met. And the conditions are really unreasonable, which would have taken a lot of time. There was no guarantee or arrangement in place that the renter would then agree to vacate the property. So it wasn't the case that we could potentially just lock up the house saying it's uninhabitable. There is a set process that everyone has to follow. Thereafter, the renter was given an option of either working with us and mutually agreed to an outcome, or perhaps we'll be proceeding ahead with the VCAT possession. And of course, things didn't work out, so we had to issue a notice. So just to fast forward again, or let's go back a little bit. The rental provider's previous property management company did issue notice without enough evidence. Please note that since the legislations have changed, you must provide enough evidence to support your case, and the reason and the act under which the reason is provided and the notice is being given must be justified. Because if the renter decides not to comply with it, it goes to VCAT. And if VCAT takes about, say, 1 month or two to hear the case, and then they feel or they find out that the reasoning provided in the notice, or the lack of evidence provided, or perhaps the notice section chosen was not appropriate, then you could go back into square one. The case would be squashed, and they have to issue notices again, and then wait for the hearing again after the period the renter was given to vacate the property, for an example. Now, in relations to the whole case there. Now, what then happened was, once we issued the notice to vacate, the renter started jumping up and down because the notice was appropriately issued, and there was still no outcome in terms of what the renter would like to do and work with us. So hearing started. First hearing was quite quick. That was in the month of April or so, and the card of mental health was played again. I wish her all the best if that's the case. Then again, we were not agreeable to that fact ourselves. But again, document evidence was provided, so I would not question or argue on that. Thereafter, legal advice was also sought by the renter. The VCAT member adjourned the case for the next hearing. We did not get a hearing from VCAT up until August, so many months. Imagine waiting for a hearing just to get your property back from a renter who's not vacating the property, who's not agreeing to the terms and conditions of the notices, can be really painful. And in this case, the renter provider had gone through a lot of financial backlashes as well. So it's really not ideal for them, the situation they've been put in as well. So we were quite keen, and there was a lot of internal meetings done in our organization, and a lot of external advices were sought as well to ensure that in the next hearing that we get the property back. So the hearing went on in August for approximately an hour and a half, a long argument. I was thankful that we got a really understanding member from VCAT, and the point to be noted there is that you have to know the acts and rental tenancy legislation quite well to be able to quote the legislation and the act with the sections and in the years they were implemented. So in this scenario, Section 330A of Rental Tenancies Act was quoted at the start of the hearing, and we ensured that we put our onus and our responsibility and rental providers' responsibility, being the house being unfit and unsafe, to VCAT as well as the renter, that we don't take any responsibility if the renter does not comply and leave the property. And if something happens because the ceiling was collapsed, if a tile falls on her, and if the renter hurts herself, then we wanted to make sure that no one is responsible from this side, which is the rental provider and our agency. So that was done as well. And VCAT was also made part of the responsibility party, where we've quoted them. If anything happens and VCAT does not comply with the request, then we hold VCAT and the renter responsible solely for any damages to the property or to the renter. There was a long conversation between the renter and the VCAT member, and the VCAT member also allowed a lawyer who was arguably not registered, in my opinion, in Victoria. That was also raised in the VCAT hearing, because when we got to know that there's a lawyer involved, we researched on that lawyer thoroughly as well, and we had a lot of information about that lawyer's capability planned ahead. So that was all pre-planned, and everything was all done in prior to the hearing. So with regards to our case, whenever the renter said something which was not appropriate, we try to object every single time and ensured that we had enough documentary evidence, and the documentary evidence which was shared by the renter's lawyer to VCAT and us also became part which we actually use against them, because in some cases the renter did agree in her email that the property is uninhabitable and she should be waived off from her obligation of paying rent. And if the argument was not to vacate the property, or perhaps the house is fixable while the renter is living in the property or getting access, where we did question ourselves, asking why can't the property be fixed, where the quotation and the notes from the tradesperson and the maintenance company or the builders clearly mention that the property is not going to be fixed if the property is not fully vacated. So that worked in our favor as well. So documentary evidence played a big role. And with regards to the objection and or interference of renter during the construction or between the construction work, is something that was brought up with the VCAT member. And when VCAT member did ask these questions, renter did agree that she feels that the construction work should be started from a different area of the house, where this actually worked in our favor, because VCAT member, my apologies, felt that yes, the renter could be one of the reasons why the property is not being fixed, and is reasonable and proportionate under Section 330 to issue the possession order. However, there was a sticking point of getting professional builders clean done, where the renter was also trying to impose that the cleaning company organized should be through her, and the rental provider must pay for it. Yes, cleaning of the debris and the dust was rental providers' responsibility to some extent. But again, at the same time, this could have been done prior. The renter also obtained a code from a cleaning company 2, 3 months ago, which was never shared with us. It was shared with the VCAT member, with the lawyer's email that sent out, and where I feel um, there was a great piece of evidence which was picked up during the email trails that we received, which was part of the case presented to VCAT beforehand by the lawyer of a renter, um, which was also again brought up in the meeting, in the hearing, where um, that it was never shared with us. Renter, sorry, has been keeping the court with her, has never shared. We could have agreed to it, or could have come up with a solution which she feels is appropriate for both the sides. And arguing the case for about an hour and a half back and forth, we got the possession of the property. However, the VCAT member provided 4 weeks time to the renter to get the property cleaned professionally through that company, plus 60 days to vacate. So she's got another 3 months to vacate the property. It is a win. At the same time, the rental provider would still be losing another 3 months worth of time, and he would not be able to, they would not be able to get the property fixed and or perhaps move on with their life, either putting it back on rent or perhaps selling. You never know. I mean, at the end of the day, such kind of financial backlash is not ideal, and it leaves a bad taste with what's happening with the legislations in Victoria. My personal view is legislation and VCAT and Labor government should ideally, that's personally my opinion, and I'm not, of course, taking this opinion from anyone. My personal opinion is that the government should actually jump in to ensure that the legislation is actually balanced, or perhaps the rules and regulations are balanced. VCAT should be given more resources, so the cases should be heard much more faster. And there's a lot of industry specialists and industry experts feel the same. So to wrap up this video today, I would like to remind you on a few things. Make sure your maintenance is done on time and through professional tradesperson. Do not just use handyman to just fix everything. Yes, it might save you money, but it might cost you a fortune down the line. So be careful when you have an investment property. Think from a worst case scenario point of view, that what if this happens? And it goes also back to the point when you lease a property. In our office, we ensure that we lease the property out to a suitable tenant. Yes, you can't understand or get to know the person until they start living in the property. However, people do leave signs when they come to the open homes. So what we feel is that the person standing at the inspection must be diligent and asking questions and assessing whether this renter is suitable for your office and your landlord or your rental provider. Because it's just like going to a nightclub. If they start letting anyone in, you're inviting trouble. So to ensure that you are doing your due diligence properly and thoroughly, make sure you select the right renter. That will solve a lot of problems. So again, whenever I pitch for new business, whenever I'm speaking with a rental provider who is going to rent the property first time, educate yourself on what needs to be done. Just don't focus on what you are getting out of it and what is the management fee the property management company is going to charge you. It's not just about the management fee. It's about a lot more information that you need to acquire beforehand. Is your property management company capable enough to fight VCAT cases for you if it all goes back? Sometimes you feel you've got a brand new property, or perhaps you've got a property which is in great condition. You don't know what things could go wrong, or the renter could actually start creating issues and then they take you to VCAT. So it's a really an area where, especially right now with legislation, that the renters do know that there's a lot of rights that they have, and we've seen it become a lot more vocal from last many years compared to last many years. So be careful when you rent your property out. That is my sole advice. And have enough evidence, documentary evidence, in your files, in the system that your property management company is using. Make sure do not have direct contact with the renter. Yes, keeping in touch is absolutely fine. When it comes down to maintenance, do direct your renters back, that they must reach out to the property managers and put the maintenance in writing via email. not text messages. You need to track it back, sometimes 5 years. If a renter goes for compensation 5 years after, and if you do not have enough evidence, you could be in a bad position. You could be at the back foot as well. Be careful. Wishing you all the best with your rental properties, or perhaps if you are a future landlord, be careful, be nice, and be nice to yourself. And you have a responsibility to yourself first before you have a responsibility to your renter. So look after yourself first before you look after anything else. Thank you so much, guys. You have a good one. This is me signing off. You take care.